Please, Your Lordship. Lord, my first respectful submission, and that, if accepted, my Lord, you may save Your Lordship's time, that the reference itself was not required. And I'll make that good, my Lord, without wasting much of the time. My Lord, kindly have a look at the reference order, my Lord. Your Lordships would find in my volume 1.
Let's keep the original volumes because just see, it will be convenient for us to look at there because we marked that volume.
I'm sorry.
Now, two volumes will create its own effort for us.
Yes. And, my Lord, some of the judgment which my learned friend did not sign, which I'll show from my volume, because there Your Lordships have not seen.
Yes. Honestly, I think the arguments have gone beyond what is the reference, what is the issue before us.
No, that's what I want to show.
No, but we are confining to the issue only. As you said, so we did not let any argument take place beyond that. We also did not let the other points. We were apprehensive about some of the other points evolving, and because of one more counsel appearing, we did not permit all those.
No, certainly, Manan. I will not.
Let me rephrase what I have in mind and discuss it. I would say on behalf of the bench. There is a protection provided to the officers. That protection in one form or the other continued for a long period of time. Ultimately, the statutory provision was struck down on the short ground that it was discriminatory, not that it was bad in law.
My lords.
Grant of protection per se was not held to be bad in law. What was held was you cannot give protection to one group and not give protection to the other. This is the limited issue on this. Now, some hiatus period occurred, ordinance was issued, and then you brought in a legislation to cure the defect which the court pointed out by giving limited protection to certain categories. Chapter is over. Now, to some extent, it's theoretical in nature because what would happen for the intervening period, how many cases they pointed out last time in some affidavit, it was stated that the number of cases were 100 odd or something, out of them some may be also over. But let's look at the facts of the petitioner. He was protected. No difficult. Because of his judgment, he became unprotected. Now, because of the other judgment, does he become protected again? So he says, as far as I am concerned, I am still protected merely because the protection was lifted for some period of time. It should not damage. And to our mind, one of the most crucial aspects is it was not merely a reenacting of legislation which took place, where it was held that this legislation was bad in law, but on the ground of a particular defect. Which defect stands cured? Would you agree that this is the position? It's the only issue before us.
But may I say, my lord, without touching the...
Except one aspect, which Mr. Datar said, which I find some force, which is a larger issue, he says, for us to say. Not in specifically this case. That when such provisions struck down, he says, look, the court must give some guidance how it will operate. So, if it is prospective, the court specifically says it is prospective. If it is to apply retrospective, it is not said. So, some scenarios maybe, it's a general observation, may be taken into account of the consequences when a legislation is struck out. So, he is really invited some, whether we give it or not.
Future guidance.
The future guidance, whether we give it or not, also I am not committing anything as yet.
It's correct.
But this is all he says, that future guidance.
It should be, my lord. I also join him, my lord, in this request.
This is the only issue on...
Lord, may I paraphrase, my lord, what I would respectfully, my lord, I think would be necessary, my lord, to assist your lordship. Lord, the reference, and kindly, my lord, don't take this, my lord, to be the final argument. I am just paraphrasing, my lord, and whatever your lordship feels may not be required to be gone into, I will not go into. And I would abide by, my lord, your lordship's tentative assessment of my arguments yesterday. My lord, I have prepared it accordingly. The reference is on the ground that whether the deletion of the provision would affect Article 20 or not. Now, the reference is made in Transmission Corporation Limited. In Transmission Corporation Limited, there are two aspects, my lord, which your lordships must be assisted with. And I am saying upfront without taking your lordship. Number one, Transmission Corporation was not a case where a procedure was sought to be amended. It was a case of a penal provision, as my lord, yesterday it was discussed, that Article 20 says that if conviction is resulted from the law in force, it cannot be changed except, my lord, whatever was the position at the time of commission of the offence should be the position. Any subsequent change in the penal provision, that's my understanding, that's my interpretation, would be bad. But that would not apply to procedural provisions.
That issue has been flagged, you are right.
Yes. Now, in entire judgment of Transmission Corporation, unfortunately, on both sides, the Honorable Court was taken on a world tour in the sense that various judgments of United States were cited. And nobody brought to your lordship's notice, notice of the Honorable Bench, a binding precedent of a 5-judge bench of this Honorable Court, which holds two things, that Article 20 does not apply to procedural provisions, and second, that for deciding the contours of Article 20, US judgments are of no value.
So this point, in fact, Justice Khanna flagged this issue at the inception itself of the arguments. What Justice Mr. Datta endeavored to do was to persuade us to take an expanded view of the matter by including it. He was conscious of the fact that there are views taken, that one is for procedural aspect, one is for substantive aspect, and but he was endeavoring to persuade us, being a constitution bench.
No,
if we could,
those judgments are of constitution bench.
You are right.
So your lordships can do that, but your lordships will have to record your lordship's disagreement and refer it to a 7th.
They are not doing anything.
No. If his attempt is to succeed,
I'm putting it very upfront to you because we've had the argument, some discussion. They are looking to a scenario where we are not going to get into the substantive and procedural distinction. They are already maintained in the Constitution. We are not referring to anything to a larger bench or something.
No, the Constitution, 5-judge bench says so.
Conscious bit. That's what I'm saying.
Yes.
I am allaying your apprehensions that we may embark on a larger path. We are not doing any larger path. We are going to decide. In fact, we feel a lot part of this would have become infructuous by reason of passage of time. Yes, the petitioner finds himself in one of the petitions, who is arguing person, in a particular position where he says, loose language, jam yesterday, jam tomorrow, no jam today, you hold me for that particular portion of time. And when the law was a flux, law was not in a flux, but something was held to be beyond the permissible levels of what the legislation should have done, based solely on the issue of discrimination. And this is something which is in mind. So once the legislature cures the discrimination issue, we can't let a scenario prevail where somebody had protection earlier and has protection tomorrow.
I bow down to your lordship.
Nothing.
Two apprehensions, my lord.
Yes.
Two apprehensions.
So you tell us where you feel.
Yes.
And also in a sense, all of you are on the same page. So that's why on the lighter side, we said we don't have a contra view arguing here. We just want to know what is in view of there being synergy on the thought processes on most issues, which are germane for this matter. What is your apprehension? Where will you think we embark, which was a matter of concern to you?
My lord, I'll be very candid, my lord, with your lordships, and I'll put it upfront. There are two apprehensions, my lord, and I'm not, my lord, trying to even attempting to be diplomatic about it.
You're not supposed to.
I'm sorry, my lord.
You're not supposed to be diplomatic about
Yeah, I'm not. We are not supposed to be many, but we end up being one.
No, you put it up. I'm putting it up front.
Yes, my lord, I'm putting it upfront. Lord, Section 6A was brought in force by the government to protect the officers of the level of Joint Secretary and up. The reason, I cannot argue that now. The reason was that the decision-making process is...
You are right. You need not labor on it, you are right.
Yeah, only a minute more. But that is now set aside on the ground of discrimination or classification within the class. 17A is couched in a different way, and my apprehension is 17A is again under challenge in a PIL, on the ground that 17A is contrary to Subramanian Swami judgment. Kindly see 17A. And therefore, my attempt is to persuade your lordships to accept my submission that 17A is different.
Just 1 second. If suppose there is a petition pending challenging 17A, ought we to foreclose all issues here in the
Your
Constitution?
lordships would not. But your lordships, my lord, being persuaded.
This is like Desai, he rightly did not try to persuade us, because we said we don't want to see, as a constitution bench, we have to be even more cautious.
Correct.
Caution is decide what is before us. Otherwise, what happens is any stray observations, any going here and there creates a problem in a constitution bench, because 3 judges benches are bound, and it results in
High courts, other courts.
and results in possibility of again a reference is arising when those courts may not have applied their mind to the issue at hand. Therefore, you take it that we will be certainly within the 4 corners of what is before us.
My lord, only thing
Go
is,
here or there.
my lord, kindly have, my lord, for my satisfaction, have 17A.
Yes, sure.
Now, your lordship's tentative view that this is 6A after curing the defect, my lord, may perhaps not be true, because their argument in that petition, which your lordships cannot, my lord, foreclose. But I can always, my lord, submit that point may not be, my lord, what was happening. I'll just, my lord, tell your lordships a little background. My lord, the country runs through the bureaucracy. Bureaucracy is not bad, my lord, always. But they give their inputs, they give their ideas, they ensure that country progresses. The hanging threat of a potential prosecution, resulted into a policy paralysis. Nobody was writing notes, nobody was accepting new ideas, and they will go by the conventional thing that we may do this, we may do that. Now, kindly see 17A, my lord.
I'm saying so. Kind of a sword over their head. Nobody will take decisions.
Correct.
So long as, and therefore, you also give permission where some decision may go wrong. That's not the problem. But it should not be for malafide reason for collateral consideration. That's all.
Yes. Lord, kindly see 17A in this
The
context.
system can work.
Lord, kindly see 17A in this context, and the attempt is to persuade your lordships that 17A is not a new avatar of 6A. Kindly, my lord, have a look at this.
Yeah.
Inquiry or inquiry, because there are 2 kinds of inquiries contemplated in CRPC, or investigation of offences relatable to recommendations made or decision taken by public servant in discharge of official functions or duties. No police officer. Now it's not CBI centric, it's general, my lord, any investigation. No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this Act, where the alleged offence is relatable to. Now, this is confined protection. Any recommendation made or decision taken by such public servant in discharge of his official duties. So that they take risks at times, my lord, in decision-making process when the country is progressing.
Has to be there.
You have to take some new ideas, you have to implement new ideas, you have to give new ideas, advise the government about the.
Criticism is that if you take a very pedantic approach, and in a scenario where various issues are moving on, stagnation is not the solution.
So, therefore, a limited protection is given, expanding.
Again, this is for a higher class of officers, those who take decisions and those who make recommendations.
Correct. But because that's the only level at which decisions are taken and recommendations are made. What happens? Your lordships are aware, my lord, with my lord's experience on this side and that side, that at the level of the officers below who do not make recommendations, they only place the facts. These are the facts for approval, for guidance, for recommendation, for decision, etc. and the file moves. At some stage, you have to take a call. For example, Lord, we would leave the courtroom after making our submissions. No responsibility. Your lordships ultimately takes the call, whether one is right or the other is right. And that is that decision-making process which is sought to be insulated from vexatious proceedings. And it's not a prohibition. It's kind of a protection that my senior will be asked whether I would have committed any.
It's a check.
It's a check. Yes.
It's a check or a protection for any government servant now, irrespective of the hierarchy, who may be involved in a process of decision making, which is a bona fide exercise of decision making process. It may it may not be right to say, I'm not sure whether at the higher level only, because suppose you are right, they say we put up the proposal, do something. But tomorrow somebody may say, even that is wrong, putting up the proposal. So the protection is given where a process is followed. You will not say the subordinate officer is not protected because he was the initiating person. The initiating person also, in a way, is a proposal. He is also equally required.
I'm obliged.
What happens? Suppose tomorrow he on record shows completely wrong facts and tries to elicit a decision on the basis of wrong facts. That's a different scenario.
It's a proposal, may not be recommendation. What happens? Well, suppose in a contract, in an award of tender, he would say that these are the three tenders, these are the plus points, these are minus points. This system which is offered is better system, but little costlier. Now place it for consideration. Sometimes you have to take the risk of costlier system which is more effective. So that's the idea. Now, my lord, the Subramaniam Swami judgment found that it is too broad and it's my lord, over wide. It's completely, there is no check. Now it is suitably tailored that every action is not checked, every action is not protected, or rather, every action is not sought to be, there is a layer of inquiry before you are subjected to criminal inquiry or investigation. Only these particular acts. But my apprehension is that your lordships, in case say that 17A is only a different avatar of 6A, that might have an impact on the pending proceedings where they say 17A.
What you were saying was that 17A seeks to cure the defect which resulted in 6 being struck down, which is that it was discriminate. So you have tailored 17A in a narrower compass, you say, but cures that defect which resulted in the judgment.
Correct.
That's the only thing.
So, my lord, if your lordship, my lord, can carefully and suitably, my lord, word it that is not affected.
Why do you think you will not suitably and carefully?
I leave it to your lordship. And my lord, third apprehension, my lord, this is an apprehension as an officer of the court. Not, my lord, this is not the government's apprehension. Lord, the law, my lords are aware. Law whereby the honorable bench declares a declaration of unconstitutionality to be prospective only is derived from Article 141 and 142. There is no other jurisdiction, and therefore Supreme Court has said that it is only your lordships who can do that. High courts cannot declare it to be prospective in application. Now, my lord, the law is that whenever a bench decides a particular list or particular question of unconstitutionality, that bench knows what has transpired before our declaration of unconstitutionality, what events have passed by, and what would be the consequence if prospectivity is not given. So it is, my lord, my submission is that the law is, it is only that bench. I'm not on this case, my lord. I have no objection if it is held prospective. It is only that bench which decides whether to make it prospective or not. If any other bench subsequently were to decide, we will have floodgates of litigations because several provisions might have been held unconstitutional without making it prospective. And now we may have petitions that now please declare that because of ABCD reasons, that judgment delivered 10 years back will have only prospective effect, or 2 years back will have prospective.
In some way, in framing the question, it became a retrospective and prospective issue. A little digression from it. It's in my view, the issue was only that a protective provision which is sought to be struck down as ultra virus on account of it being discriminatory, not per se bad in law. But discrimination is causing the consequence. You have to construe it in a particular manner. Not saying, my brother Justice Oak itself said, we can't do it. We can't say if it is violative of constitutional part 3, that it will have only prospective effects, because that doesn't exist. But we'll have to tailor the peculiar problem which we have here. That's all we are looking for.
Lord, the suggestion is, if your lordships can consider saying that without laying down the law in view of the peculiar facts arising this, let this be held prospective, because very few number of cases are going to be.
Open even to say that this is, it is not prospective in that sense, but being a prospective order, what is to be done? Maybe we use Article 142 to complete justice between the parties.
No,
But in the given scenario, 142 is only for scenarios like this.
because
But
when there is no,
we are not laying down the law that such provision against the principle that unless it is set prospective, apply it. All that cannot take. Those may not have.
difficulties, and I'm fagging Mulad as a student of law again, not Mulad as a party appearing.
That all of us are.
Yes. Mulad, jokingly, Mulad, it says that the judges are law students who mark their own examination papers.
So we actually mark the examination paper
Of other judges also.
of the other judges and of lawyers also who are making submission.
Yes, Mulad, your lordships are right, Mulad. And sometimes, Mulad, the assessment takes place in the chamber,
Yes.
may not be in the courtroom. Mulad, the difficulty is what Subramaniam Swamy judgment, what the bench deciding Subramaniam Swamy judgment bench could have done, would have done only under 142, if at all it was to be given prospectivity. Now the question would be, can a subsequent bench do it? And if that is done, would it not permit others to come for other judgments?
Understand.
That now you also exercise 142 and make it prospective. That is my apprehension.
We say you are being unnecessarily apprehensive. There is an old saying कि बहन का इलाज लुकमान हकीम के पास भी नहीं.
Lord, your lordship knows the ingenuity of our litigants. Lord,
No, of course, ingenuity of litigants and your community's ingenuity, we of course are quite aware of.
Lord, I didn't want to
Your ability-
ask, my Lord, but it is our ingenuity, my Lord, which we hire.
And your ability is both. That is how. That is
Lord,
why you are there.
My Lord, suppose, hypothetically, just, my Lord, presumption, there is no such provision, case. Some provision of, my Lord, say, Mines and Minerals Act is declared unconstitutional, either on the ground of competence or on the ground of violation of article, something has happened in between before before declaring it unconstitutional. The bench declares it to be unconstitutional, does not make it prospective. And a petition is filed that now please declare it to be prospective. Can another bench do it? That would be the question.
And then no, I will slightly differ. See, even what is he talking about? He is saying for future lay down some guidance principle. Though I'm very doubtful we can as such lay down guiding principle. Only thing is we are flagging an issue, not even laying down a guiding. We are flagging an issue that while striking down a provision is unconstitutional, the bench is expected to look into the issue of the consequences. Beyond that, we can't say in this scenario you will do so. Again, it's quicksand to step into these issues. That we will not do. We are, I sometimes repeat, we are not theoreticians. We have to decide.
Lordships can consider saying it is desirable.
We have a list between us. Our job is strictly to decide the list between the parties, not to go beyond.
Yes, my Lord, but not in a constitution bench format. My Lord, that list may or may not be relevant. But your lordships are deciding the question.
No, but we are not going to go here and there to decide.
No, correct, my Lord. Correct, but that's
Mehta, the difficulty was before the constitution bench. Yes, they had only deleted the words joint secretaries and above. It would have led to heaven because there would be large number of other cases where their junior officers would have been prosecuted. They would have then got protection of success, which could not have been.
That cannot be done.
It cannot. So what they did was they struck down 6A, saying that it was discriminating. Now, the very, very limited issue arises. Somebody is saying that in spite of the section being struck down, that protection will continue because I had committed the offence is alleged to have been committed during the when 6A was in the statute books. So declared by the court to be ultra vires.
That is on prospectivity, not Article 20.
No, yes.
Yes.
So now, one is the plea taken on Article 20, which we'll have to deal with, saying that this protection is covered by Article 20 even if it's procedural. That we'll have to answer that one way or the other.
One way or the other. Not that it is covered.
Not it's
Lordships can say it is not covered.
correct. You're right, and therefore you have taken up the plea that it is procedural and therefore not covered. It's only the substantive.
And there is a substantial law.
Yes, you may be right on that. Let me put it. You may be right on that. There's substantive law, and you just I don't remember this. I don't know the judgment which you read.
Well, that is Rao.
But that
Rao Shiv Bahadur. 588.
our understanding was also the same. We put that query to.
Yeah, my lords yesterday put that.
Now the other issue is what is the effect thereof. The real issue is what is the effect thereof. When a statutory protection is withdrawn or struck down as unconstitutional, should we say that it should apply prospectively and not retrospectively? Because certain anomalies may flow in case we say it will apply prospectively. You are saying that we should not do it under as a second bench, we should not be able to do it. But that may have its own consequences. Sometimes as judges, we may not be able to appreciate the full consequences. Look, legislation, when it is made, it studies data, it examines various. We do not have that privy. Probably the bench may not be aware how many cases are there at the time when the judgment was pronounced, wherein 6A issues arising. So we may not be privy. So to say that the court cannot, in a subsequent bench, declare that it is prospective, may be a little difficult. In any case, suppose a review had been filed or curative had been filed, and we have cases wherein you have been filing curatives even with regard to the appointments, etc., of police officers, where we have modified the directions, keeping you the difficulties expressed.
Sir.
So that power, if you feel that power should be taken away from us,
No. No. My lord, nobody can take it away. Your lordships have conferred that power on your lordships, and only your lordships can take it away. I'm not on that.
we
But the judgments have said so. That's my worry. It's not the case, my lord, as a proposition of it.
I'll give you an example. Suppose curative or review comes later on. That bench may not be available at all to decide who is to decide the review of curative. We don't shut it out. You are in a review. If I may say so, on a constitution bench, which we have listed in the month of January, where you have come after, the government has come after 19 years in a curative petition without a review. Can we say this cannot be decided by any other bench than the bench which decided it?
No, but yes, union carpet. Your lordships are right. Lord,
Therefore, we are circumspect in laying down very wide parameters for anything. Because there may be exigency of situation. Here the exigency is, and you are appreciating the exigency where, I don't know how many cases are left, but there is a hiatus period.
Mostly would be 2, subsection 2
you are
of
also wanting, as you have reframed 17A, a protection to be available against alleged to have been committed by a public servant under this act, where alleged offensive is relatable to recommendation made or decision taken. You yourself, the legislature in its wisdom, has given this protection.
Correct, my lord. I am not against the protection.
So protection was earlier there, protection is now there. The protection, in some sense, you are saying is narrower because you have worded it in a more restricted way in some ways. But it is expansive in the sense that it doesn't restrict it to a particular category of persons, which was the cause for striking down as discriminatory. Therefore, that being the position, I thought everybody is on the same page, but we have to find a solution for the peculiarities of some cases which may be still pending. Like
You and Fab,
how to deal with them, that's the only thing.
Lord, Lord, that's the position, my lord, in
We are clear with what we want to do.
Lordship. Only one last apprehension, which I may share. Lordship knows, my lord, Transmission Corporation refers to the larger bench saying that effect of Article 20 needs to be examined by a Constitution bench. In 2010, Constitution bench said that now this becomes academic, and I'm sorry, and therefore we will not go into it because there is a new law in force. Again, my lord, another bench, my lord, referred it back to the larger bench. Lord, may I show only 3 or 4 judgments on Article 20, sub-article 2?
Yes, please do that, and with that we can close it.
Correct. That's all. And my lord, another thing, and I'm not going to argue this. I join my learned friend, my lord, in a request that there may be some guidance for future that while declaring a provision to be unconstitutional, it is desirable. May not be possible in all cases. It is desirable that the bench itself decides whether it should be prospective.
Sirista, I'll only change the phrase. Instead of guidance, we'll flag this issue. So that
Yeah, whichever way.
we flag the issue for further courts, that in certain scenarios it may be desirable to get into.
Yes, sir.
So that it's a little consciousness call. That, we should look at the wider connotations of such an.
Understood. But another thing,
You have to leave something for innovations and lawyers also. We clarify everything.
My brother says we must leave something for the lawyers. Otherwise, if we clarify everything, what left to be argued by lawyers and further proceedings.
your lordships are right, my lord. Everything should never be settled. My lord, another thing, and I'm not going to argue this, my lord, for your lordship's assistance. My lord, we have analyzed and, my lord, prepared the list of judgments where your lordships were pleased to say the grounds on which prospective overruling doctrine can be applied or may not be applied. That, if your lordships can consider, so that for future guidance, that ultimately your lordship would only flag. I have only one copy, other copy being, my lord, printed, but these are all judgments where, for example, my lord, it says that prospective overruling not to be exercised generally in service matters. Then, my lord, when it is to be exercised, what are the fetters?
Keep in mind. Writer side, I'm conceptually against writing theses.
Lord, that's your lordships may say this in the judgment, my lord. Everyone would be happy.
I've said so.
Everyone would be happy.
I've said so in judgments that we are here to decide on this. We are not theoreticians to decide a theory.
Because in many judgments, especially, my lord, larger bench judgments, A concurring with B, B dissenting with C, but C concurring with A. We do not know, my lord, what ultimately who concurred with whom.
That's the consequence. Affects courts sitting in benches. Fortunately, unfortunately, that's the scenario. We generate so much of volume, we can't sit together and decide everything.
And, my lord, your lordships would know better. In earlier judgment, 5 judge bench judgments, reference cases, 5, 6, 7 pages, and the law was crystal
But
clear.
then we were never burdened with 5 volumes of judgments, another 5 volumes from this side, 10 volumes. We had
Lord, there were no Xerox copies and there was cut paste.
There was no cut page, there was no computers. So nobody could at a click of a button, you have to do research, get all the judgments.
And
Now all these compilations are thrown at us and everything is reported. SCC also wants to make 20 volumes. Every reporter wants to make 20 volumes. Therefore, whether something is reportable, an order, distinction between an order and judgment is also lost. Every order is reported. So we are actually inundated, I think, with case law. That is causing some constraint in writing and also creating volumes. Unless possibly we adopt the US system, partly we do, where they just refer to, below that line, they refer to judgments, refer to 15 will be charged. There is no discussion beyond that.
footnotes. That's
Only footnotes.
or my lord, not a practical solution. There is a law that judgments would be written only in manual typewriters because the once 2 lines are amended by the honorable judge, the entire page will have to be retained. Lord, that makes it very crisp and brave. Otherwise, my lord, your lordships are, this is on a lighter side. Obviously, it cannot be done. But otherwise, my lord, it's impossible to cull out the ratio.
There is a I always say it applies to, I think, to drafting of petition.
Pleadings and judgments. Yes, yes.
There is a, in English grammar, I read a book, I think all of us at some generation read it, of Wren and Martin.
Wren and Martin, yes.
It's a red book. I always say in different forums of judicial academies, there's a very nice chapter on pressy writing.
Pressy writing.
Please read pressy writing. It's far more difficult to write 5 pages than to write 10 pages.
Lord Winston Churchill once wrote a letter of 10 pages to his friends, and he started that kindly pardon for a longer letter because I didn't have sufficient time to write a shorter letter. Because to write something very precise, concise, and short, you must be very, very clear about what you want to write.
That applies both sides.
Yes, yes, more on our side. Lord, we also,
both sides.
Lord, we also Lord, quote judgments, paragraphs of the judgments, and everything. Lord.
Actually, the one challenge has been the inundation of case law has created a challenge for us, which in 1950s the courts did not face. So you have 3-4 pages opinions which are there. They were not burdened with this volume of case law, nor were the legal fraternity burdened. So nobody, as you said, many technology changes have brought their own issues with it.
Yes.
There are not many reviews.
Whispering aloud what brother says. He said there were also not many reviews and curative petitions.
That is ingenuity on this side, Manoj.
So sometimes we opened a curative petition issue. Today, I think in 1 month I must have signed at least 50 matters of curatives. So sometimes in trying to cure, you create a situation, but that cure creates its own problems.
Yes.
You wanted to point out those couple of judgments?
Lord, a few judgments, Manoj, only, and I will not be repetitive on Article 20, Sub-Article 1.
You've taken cognizance. I think that
Yes. Lord, please come to, Lord, my volume 2, because this is not in their volume, or they have not referred to some of them, and therefore, Lord, your Lordships must not have marked. This, I'm sorry. Lord, I have checked up. In Transmission Corporation, only American judgments are cited, I have already pointed out. Even those judgments says what our courts have said. It doesn't say that procedural thing. I do not know, Lord, what prevailed upon us on this side not to assist the court with these binding judgments of constitution benches, which says that American judgments can be relied upon for Article 20 interpretation. Please see, Lord, 484.
One of the judgments, at least Mr. Datar referred to, I found that passage there that the American judgments have their own limitations in context of the American Constitution.
Correct. Every constitution evolves based upon our social ethos, our problem, financial position of the nation, etc. But a constitution can never be interpreted based upon judgment of other countries' constitution. But kindly come to page 484. At, my lord, page 488 first.
Yes.
Lord, at 488, somewhere in the middle, Lord, since I am not taking your Lordship's time, I am not reading the full. Lord, somewhere in the middle, if your Lordships can come, which starts with on the footing, 10th line from the top. Lord, this is a constitution bench judgment. 5 judges in 53. So this Transmission Corporation had the advantage, but was not placed for your Lordship's consideration. On this footing, your Lordship gets him?
Yes.
Soon after Keshava Madhavan Menon?
Yes, my lord.
Three lines below that. 3 lines below that.
Yes.
From Madhavan Menon. 3 lines.
Keshwan Madhavan Menon, which documents are that?
Minister, instead of, if we take any of the SCRs, SCCs,
The classitem.
photocopies, the advantage is that the concerned line and passage are there. SCC online doesn't have that facility.
Correct. And the classic term is also, classic term is not there. Please, on this footing, it was argued that even on the assumption of the convictions in this case being in respect of new offences created by Ordinance 48 or 49, after commission of the offences charged, the fundamental right guaranteed under Article 20 is not attracted thereto so as to invalidate such conviction. The contention, however, cannot be upheld. On a careful consideration of the respective articles, one is struck by the marked difference in language used in Indian and American constitutions. Section 9(3) and 10 of Article 1 of American Constitution merely says that no ex post facto law shall be passed and no state shall pass ex post facto law. But in Article 20 of the Indian Constitution, the language used is in much wider terms, and what is prohibited is the conviction of a person or his subjection to a penalty under the ex post facto law. The prohibition under the article is not confined to the passing or validity of the law, but extends to the conviction of the sentence and is based on its character as ex post facto law. The fullest effect must therefore be given to the actual words used in the article. Nor does such a construction of Article 20 result in giving retrospective operation. Lord, Your Lordship, we can skip and kindly come to para 9, the heart of the matter in my respectful submission. In this context, it is necessary to notice that what is prohibited under Article 20 is only conviction or sentence under an ex post facto law and not the trial thereof. Such the offence or the court different that which had competence at the time, I'm sorry, my lord, such trial under a procedure different from what obtained at the time of commission of the offence, or a court different from that which had complete competence at the time, cannot ipso facto be held to be unconstitutional. Procedure is not hit by Article 20, as my lord at the outset pointed out. A person accused of the commission of an offence has no fundamental right to trial by a particular court or by a particular procedure, except insofar as any constitutional objection by way of discrimination or violation of any other fundamental right may be involved. Now, Your Lordship, my Lord, kindly come to what argument would be. This is a Constitution bench judgment, 5 judgment delivered in 53, not taken note of in Transmission Corporation, while saying whether it applies to procedure or not. First of all, it was not a procedural provision in Transmission Corporation. It was a penal provision of sentencing. So that question perhaps did not arise. Nonetheless, my Lord, now kindly, my Lord, come to the next judgment, 499, my Lords. That is State of West Bengal. Again, my Lord, a Constitution bench judgment, which was not placed, my Lord, for your for the consideration of the court. Here, my Lord, the court, para 13.
Could you repeat the page, please?
Lord, I'm sorry. It is page 499.
490.
In my volume number 2. The citation I have given in the volume, so I'm not referring to the citation. Court comes out with a little nuanced argument on Article 20. That is para 13, 14 and 16. If your Lordships can, my Lord, oblige me by coming to page 505, running page 505. Lord, this was a case where in Calcutta, there was a divergence of view between two honorable judges in Calcutta High Court. I'm saying that because the names are mentioned, my Lord, that this view is right or that view is. That's only relevance, nothing else. Para 13. This brings us to the contention which was found favor with Justice Bhattacharya, one of the view. Namely, that provisions of section 13(3) is a punishment, and that as 1944 ordinance was not in force at the time when the offence was committed, section 13(3) could not be applied to the respondent, inasmuch as Article 20 subarticle 1 lays down that no person shall be subjected to a penalty greater than what which might have been inflicted under the law in so-and-so, so-and-so, so-and-so. Your Lordship will now come to 14. I read 13 for the background. we do not think it necessary for the purpose of this appeal to decide whether the facts that the respondent continued in office till so and so, and the ordinance came into force on so and so, would take the case out of the ambit of Article 20, Subarticle 1, for we have come to the conclusion that the forfeiture provided under Section 13(3) is not a penalty at all within the meaning of Article 20, Subarticle 1, and the second argument urged on behalf of the appellant must prevail. Now, the 1944 ordinance is an independent ordinance, as is not an amendment to 1943 ordinance. It is, my lord, that's all, my lord. Then kindly come to para 16. My lord, a different dimension, my lord. The same question is examined from a different dimension. We may, in this connection, refer to Rao Shiv Bahadur Singh, the first judgment which I read, versus state of so-and-so, where Article 20, Subarticle 1 came to be considered. In that case, it was held that the prohibition contained in Article 20 of the Constitution against convictions and subjections to penalty under ex post facto law is not confined in its operation to post-constitutional laws, but applies also to ex post facto laws passed before the Constitution in their application to pending proceedings. Now, this is important. This court further held that Article 20 prohibits only conviction or sentence under an ex post facto law and not the trial thereof. Such trial under a procedure different from what obtained at the time of the offence or by a court different from which had competence at that time cannot ipso facto be held to be constitutional. Now, this is the new nuance, my lord. Can you, my lord, have a look at this? Therefore, this case shows that it is only conviction and punishment as defined in Section 53 of the Indian Penal Code, which are included within Article 20, Subarticle 1, and a conviction under an ex post facto law or a punishment under ex post facto law would be hit by Article 21. 53, if your lordship sees, your lordships may also see Section 2, subsection 38 of General Clauses. The Constitution bench says that it is only when this is the result, imprisonment, etc., death penalty, etc., that Article 20, Subarticle 1 applies. Not to procedure, and even forfeiture is not treated to be a punishment, my lord. And kindly see 53. It's not quoted, my lord. Your lordships can have, my lord, IPC 53. Even fine is a punishment. But rest is outside the scope of Article 20, Subarticle 1. And General Clauses Act also, if you can. Your lordships are aware, General Clauses Act applies to interpretation of Constitution under 366, 367. 53, your lordships have?
Yes.
The punishment to which offenders are liable under the provisions of this code: death, imprisonment for life, imprisonment which is of two descriptions, rigorous or simple, forfeiture of property, and fine. So, if it is not falling within any of these, it's not protected under 20 Subarticle 1. Here, their case is that I am being tried in a procedure different from what from the procedure which I had when I committed the offence, and the procedure was no trial without the sanction under 6A. 20 Subarticle 1 is completely out. And 238, offence shall mean an act or omission made punishable by any law for the time being in force. And this is General Clauses Act. And General Clauses Act applies while interpreting the Constitution. That's, my lord, Article 366. Lord, your lordship may just mark, note, your lordship need not see, Section 2N is the same definition in CRPC. Offence, which is the word used in Article 20, Subarticle 1. Conviction for an offence is protected under 21. An offence means something should result from out of section 53 of the IPC or 238 of General Clauses Act or not the CRPC. Now the next judgment, my lord, I am just taking your lordship, lord, 519. It is, my lord, a 3-judge bench decision, my lord. And only one para, my lord, para 6, para 16, I'm sorry.
519.
519, my lord, and para 16, your lordship would find, my lord, at there is one page missing, my lord, but nothing turns on that missing page, my lord. My lord, kindly the 6, not 16, my lord. Para 6 at 521. And last 5 lines just before Maxwell in his book, my lord. I'm just, my lord, trying to confine my arguments not to read the whole. It starts with but an ex post facto law. The lordship gets that, my lord?
521 is.
Para 6.
Yes.
Yes, my lord. Para 6, there is a quotation from Maxwell in his book, Interpretation of Statutes.
Yes.
Just above that, my lord, 5 lines. But an ex post facto law,
Yes.
which only mollifies the rigor of a criminal law, like, my lord, sanction, does not fall within the said prohibition. If a particular law makes a provision to that effect, though retrospective in operation, it will be valid. The question whether such a law is retrospective, and if so, to what extent, depends upon the interpretation of a particular statute. But, my lord, it says that if some rigors of the procedural criminal law is mollified, it would not be protected by Article 20 sub-article 1. And, my lord, your lordships would bear one factor in mind. All these judgments are considering legislative enactments which were challenged on the ground that they violate fundamental right, namely Article 20. A judgment of the court can never violate fundamental rights. That is 9-judge bench Miraj. A judgment cannot be argued that unless you interpret it in this fashion, it would violate my Article 20 rights. The argument is that unless you include the procedural part in Article 20, the law laid down in Subramaniam Swamy would affect my Article 20 rights. But it's a wider question whether that can ever be raised. A legislative provision can be attacked on the ground of violation of Part 3, not the judgment. That's not 9-judge bench. Miraj Karma, it's 66, Volume 3, SCR 744. I'm not troubling your losses. The law is too well settled. Then 529, another constitution bench, again prior to Transmission Corporation, and ought to have been, in my respectful submission, as cited by us, 529, us means on this side, and the paragraph is, 4 and 20. Whether, kindly see para 4 at page 529, my lords have got. Mittal J, Justice Mittal held that section 23(1)A violated Article 14 of the Constitution and was accordingly ultra vires the Constitution, and that the relative provision of section 23D must also be condemned. Regarding the second point, namely, whether section 23(1)A, having been substituted by the amending Act of 39, Act 39 of 57, would have retrospective operation in respect of the alleged offence which took place in 1954, the High Court came to the conclusion that petitioner had a vested right to be tried by an ordinary court of land with such right of appeal as were open to all, and although Section 23(1)A was procedural, where a vested right was affected, prima facie it was not a question of procedure. Therefore, the High Court came to the conclusion that provision as to adjudication by the Director of Enforcement could not have any retrospective operations, etc. My Lord, kindly come to para 20, the finding of the Constitution Bench. Again, my Lord, a very small judgment running into 4-5 pages. Para 20, my Lord. Mr. Chatterjee, your Lordships have heard. Mr. Chatterjee, the learned counsel for the respondent, urges that a substantive vested right to be tried by an ordinary court existed before the amendment and relied upon Maxwell, where it is stated the general principle, however, seems to be that alterations in the procedure are retrospective unless there is some good reason against it. He says that there is a good reason if the principles of Article 20 are borne in mind. In our opinion, there is a force in the contention of the learned Solicitor General, as observed by this court in Rao Shiv Bahadur Singh, the first judgment, my Lord, of the Constitution Bench, which I read. A person accused of commission of an offence has no vested right to be tried by a particular court or a particular procedure, except insofar as there is any constitutional objection by way of discrimination or violation of any other fundamental right is involved. 6A being there or not being there is procedural. There is no principle underlying Article 20 of the Constitution which makes a right to any course of procedure a vested right. Mr. Chatterjee complains that there is no indication in the amending act that the new procedure would be retrospective, and he further says that this affects his right of appeal under Criminal Procedure Code. But if this is a matter of procedure, then it is not necessary that there should be a special provision to indicate that the new procedural law is retrospective. No right of appeal under the Criminal Procedure Code is affected because no proceedings had ever been started. So that is on the facts of the case. But right to be tried by, there is no vested right, and even if there is a vested right, it would not fall within the protection of Article 20 sub-Article 1, because it doesn't result into conviction or does not result into conviction. You cannot change, you cannot make out a new offense. You cannot enhance the penalty. You cannot do it twice over as per the second part of Article 20 sub-Article 1. The procedure can always be changed. Suppose pending trial, there is a legislative enactment that instead of a particular court, the offences would now be tried by a special court. But that would not hit, would be hit by Article 20 sub-Article 1. My Lord, last judgment on this, my Lord, is page 533, para 7. Rest, my Lord, I have skipped. And please see the facts, my Lord. They are narrated in brief at para 534 in my Lord, the detailed head note. Only one and two detailed head note. What were the facts of the case? Somewhat similar, therefore, my Lord, I am pointing out. Lordship, have page 534.
Yes.
The my Lord, detailed head note at 534, my Lord. The appellant was charged under Section 60 in 1963 for offences under Section 120B and 161 IPC as well as Section 5 of Prevention of Corruption Act. The trial court, by its order dated so-and-so, acquitted the appellant, holding that as Section 5(3) had been repealed by Act of so-and-so, and as no specific instance of payment of bribe to the petitioner could be proved, the accused could not be held guilty of charges. An appeal was filed to the High Court, and during its pendency, Act number so-and-so came into force, reviving Section 5, subsection 3. The High Court upheld the validity of the Act and remanded the case for trial from the stage at which it was pending. In appeal before the Supreme Court, the appellant contended that the trial cannot take into account the provisions of 5(3) after its repeal on December 1864 and 2. Article 60, Act number 16 of 67, which revived 5(3) and made it applicable retrospectively, was void and unconstitutional, being violative of Article 14 and 20 sub-Article 1 of the Constitution of India. Now, para 7, my Lord, is the finding. This is by the honorable two honorable judges, my lord. Lord, para 7, my lord, Mr. R.K. Garg, my lord, shows Article 20. Can you, my lord, come to page 540, the first line?
Yeah.
Usually, your lordship gets that. Usually, a law prescribes a rule of conduct by which persons ought to be governed in respect of their civil rights. Certain penalties are also imposed under the criminal law for breach of any law. Though the sovereign legislature has power to legislate retrospectively, creation of an offence for an act which at the time of its commission was not an offence, or imposition of a penalty greater than which was under the law provided violates Article 20, sub-Article 1. It is well-known case of so-and-so and also American case so-and-so. The principle underlying the provision has been fully discussed. Please mark this, Mr. All that Article 20, sub-Article 1 prohibits is ex post facto law and is designed to prevent a person being punished for an act or omission which was considered innocent when done. If I do something today, it is not a punishable offense, and the legislature makes it an offense tomorrow, retrospectively. I never knew while doing this that it's an offense. That's the long and short of Article 20, my lord. Kindly, my lord, thereafter skip Rao Shiv Bahadur Singh's quotation and only one para. Thus, the appellant cannot object to a procedure different from what obtained at the time of commission of the offense. The offense that was committed was when Section 5(3) was in force, and by Act 16 of 67, the procedure is revived. It is not as if the procedure is brought into force for the first time. Lord, this is to buttress my respectful submission that mere procedure, mere change in procedure, or mere change in some stage of trial would not be hit by Article 20, sub-Article 3. These are my submissions of Article 20. Lord, only one judgment, my lord. Lord, as your lordships have already, my lord, indicated, whether it is void or whether it is operating, etc. Lord, in my consideration, for the simple reason that all these judgments, my lord, which were cited by my learned, were recently considered. And, my lord, only one para I will read where, in my respectful submission, the crux of the law laid down by your lordship so far is earmarked and is given, my lord. So it was a separate.
It was this.
Yeah. Is void, completely void. तो नागेश्वरराव नहीं होंगे, अलग अलग लॉर्डशिप में क्यों में we are forgetting the एक तो है what will have the box. कौन सा था? State of Manipur. Manipur. Lord, dear lordships, there's a citation. Lord, in the meanwhile, I'll just, there's some confusion at our end. Lord, only two judgments, Lord, for assisting your lordship. If your lordship finds it necessary, I may read two passages from Golaknath. Golaknath, Lord? Not required. Then, Lord,
Yes.
only one judgment, my lord, in that case, my lord, Murthy. Lord, that is in my volume 2, my lord, the same volume your lordships had.
Yes.
I'm sorry. Thank you. Yes, my lord, 479. To assist your lordships, my lord, nothing, my lord, so far as I am concerned, it may not, but for future, my lord, it may not be said that we committed the same mistake which our counterparts committed in Transmission Corporation. At 482, para 8, my lords. Lordships have the book.
Okay.
The learned counsel for the appellant submitted that the approach of the High Court is erroneous as the law declared by this court is presumed to be the law at all times. Normally, the decision of this court enunciating a principle of law is applicable to all cases irrespective of its stage of pendency because it is assumed that what is enunciated by the Supreme Court is, in fact, the law from inception. The doctrine of prospective overruling, which is a feature of American jurisprudence, is an exception to the normal principle of law, was imported and applied for the first time in L.C. Golaknath versus so-and-so. Prospective overruling is a part of the principles of constitutional canon of interpretation sorted to by this court while specifying the law declared by it earlier. It is a device innovated to avoid reopening of settled issues, to prevent multiplicity of proceedings, and to avoid uncertainty and avoidable litigation. In other words, actions taken contrary to law declared prior to the date of declaration are validated in larger public interest. The law as declared applies to future cases. It is for this court to indicate, please mark this, Madam, as to whether the decision in question will operate prospectively. In other words, there shall be no prospective overruling unless it is so indicated in the particular decision by the same bench. But I have no objection, my lord, in your lordship saying that. My worry is that if the
This is why in the beginning, when the petitioner had died, I had said that, please correct me, my understanding is, where prospective overruling has to take place, it must specifically say so. It's a settled proposition.
my lord, we may not have petitions that for other judgments now hold that it is prospectively applicable. That's the only, my lord, apprehension. And my lord, one last judgment, my lord.
Last, the last.
La-
Yes.
Isn't it? My lord, my lord, I'll present a note, my lord, for your lordship's consideration. Your lordships may consider ignoring it, my lord, by writing the judgment. If your lordship considers needs to be quoted, my lord, maybe the citation part only, may not be the whole thing. What are the factors the court would consider for declaring a particular provision, a particular judgment to be either prospective or retrospective in nature? There is a case law on that, my lord. And that, my lord, I don't wish to read it, but I am not placing it. My lord, if your lordship feels, your lordships may, for future guidance, indicate that these are the parameters, which of course would never be exhaustive parameters. My lord, parameters may change from fact situation to fact situation. New challenges, your lordship would devise new ways of doing complete justice under 142. But these are, my lord, the broad parameters settled so far. Lord, last judgment, my lord, I am not. Lord, it was a Manipur
Which you could not locate at that time.
Pardon?
Which you were trying to locate and you could not locate.
Yes, sir.
Circulated.
Yes, my lord, there, I'll just see the proposal. I'll show the proposition. Proposition is all the judgments, my lord, that if it is legislatively incompetent, it is void ab initio. If it is violative of part 3, it is merely inoperative. Every judgment is considered, and the 3 honorable judge bench, my lord, said that this is the crux, that it is distinction without difference. The phraseology is mine. That ultimately it is void unless
Is it in your compilation, Mr. Dutta?
it will not be.
But this is exactly what was said by many benches that don't make such a distinction, right from basic custom.
But you can cure the defect.
That it is now reaffirmed a lot, so that in a sense.
Then I am not opposing you with that.
Your Honor,
He is saying
not
that if
this.
you have this thing, it will help him. That's all.
Yes, certainly.
But
Look, this is a distinction.
In Pisikaka, that was disapproved with the review in 5 judges. And again, subsequently in judgment, they said there's no distinction. If your lordship declares the law, it's invalid. That's all, both ways. And this is, Matthew points out, incompetence is a restriction subject-wise, whereas part 3 is a restriction right-wise. That's how this Matthew makes it.
Well, only thing I'm respectfully urging is in none of the judgments there was a question where after the declaration of invalidity or unconstitutionality, there was a curing of defect. So this judgment says that except in second case, you can cure the defect. Second case meaning thereby when the law is declared unconstitutional as violative of Article Part 3, as my Lord Justice Khanna yesterday indicated, that some provision is declared unconstitutional on the ground that you are not provided for hearing. And the legislature fills up that lacuna. So it would be void till it is cured. So whether it is from the beginning, etc., my Lord, may perhaps not arise, my Lord, in facts of the case.
Thank you. Yes. Anything else, Mr. Datta?
And my Lord, there is, I'm so sorry. What is that?
The legislature intervenes, then legislature, etc.
My Lord, I'm sorry, my Lord, one judgment, my Lord, for my
You will
satisfaction.
keep looking to your left, you will keep reading your judgments.
No, I'm sorry, my Lord. We work, my Lord, a little late, my Lord, so it's not part of my initial compilation, my Lord, and we always, my Lord, it's 1963, 2 SCR 747. This would have, my Lord, relevance, my Lord, would really assist your Lordship. It's a unanimous 5-judge bench judgment.
1863.
Volume 2 SCR 747, sorry, 747. Where Deepchand and all other judgments are considered. And this is a constitutional, para 16. That takes us to the larger issue raised by Mr. Nambiar. The Lordships have that one. Para 16, 16. Para 16. That takes us to the larger issue. That takes us to the larger issue raised by Mr. Nambiar in the present appeals. He contends that the power of legislature to make laws retrospective cannot validly be exercised so as to cure the contravention of fundamental rights retrospectively. His contention is that the earlier act being dead and non-existent, the impugn notification contravenes Article 31(1), and this contravention of a fundamental right cannot be cured by the legislature by passing a subsequent law. This is not the question, but I may not trouble your Lordship. This he has also not fairly argued, my Lord, that curing of defect is not permissible, is not a case.
Thank you. That's all.
May I make a few? Lord, may I make a few submissions?
Yes, you have to add something.
Yes, I have to add slightly. I will not add to what my the learner has just said, but slightly different one on the consequence. Supposing I am only on mainly on the consequence, if it is held that it is, my Lord, it is prospective and not retrospective, etc. My Lord, what is the consequence? I am only addressing my Lords on the consequence part, because other parts have been dealt with by the learned estate.
Just one. Do we take it that your stand is after the stand of the government of India, Union of India, is that after the judgment in Subramanian Swami's case, the accused is not entitled to rely upon Section 6A as invalidating the prosecution? Is that the stand?
That would be the stand. And the alternative stand is, even if 6A applies, what would be the scenario?
No, that's something separate. The first and foremost stand is 6A is per se not applicable and cannot be taken as a defense. Violation of 6A cannot be taken as a defense.
That
In any case, protection is provided in terms of sanction.
Yes.
Before the prosecution is filed, sanction has to be obtained.
And there would be protection even
Sir,
in the
only one, my submission was that it would not be hit by 20 sub Article 1.
No, for-
If your lordship makes it prospective, they can take
No,
protection of 6.
that's the second part.
Yes.
That if we hold to the contrary, then it is not hit by section 20. Obviously, if we hold that it is not, it's retrospective, then it is not hit by Article 20 clause. Otherwise, it has to be, it will be always prospective.
Yes.
Because otherwise, if we say that it's not a part of procedure but substantive law,
But your lordships can under 142 say that let it be let the judgment be prospect, and the protection which was available may continue to be available. I am not against that protection.
My stand is the
I
same.
just wanted to clarify that the procedure is not a part of 20 sub-article 1. That's
Mr. Mehta, just be very, I think you were very clear in your submission. You said it's a part of 6A is a part of procedure. So once it's declared to be unconstitutional, being a part of procedure, no substantive right is given to the accused. The judgments are retrospective because they declare the law. They do not create a new law. And therefore, unless the judgment itself says it is prospective, or we say it's prospective, it will be retrospective,
or the defect is cured.
or the defect is clear.
Grateful.
In any case, one thing is there, one argument. See, it's the part, 6A is the part of inquiry or investigation at the initial stage. It's not even at the stage of filing of the charge sheet or cognizance or framing of the charge, because in that case, again, you have to take prior sanction. That is the mandate. Even if there is it the case that if sanction is granted or approval is granted on the 6A, then you don't take sanction on the 19? That's not the case. You have to take sanction on the 19
Because sanction will be after the evidence is collected.
after evidence is collected. So it's really at the initial stage. So protections are multifariously built into the system itself to protect the innocent or anybody being prosecuted, wrongly being prosecuted.
Right.
The only concern which we were a little bit concerned is with regard to 17A, because that's a very, very important provision.
Yes.
It should not be affecting the policy making.
In fact, my stand is that 17A has to apply. That is my stand. Whether
That it will apply retrospectively.
it will not.
It will not apply.
Why? I'm not saying it will apply retrospectively.
Cannot. It will lead to difficulty.
I'm saying that today, because the investigation today will start once my lords hold that as far as 6A, the striking down of 6A is retrospective. But my lords may kindly have a look that it applies 6A, and the rigors of 6A will still stand for the intervening period from till to May 2014 till the judgment is delivered. That is one stand which the other side has taken, my lord, if my lords recollect. They say that the immunity will continue. That's
Correct,
what they're saying.
Because they brought it under the
Yes,
immunity.
my lord. Now, what is the effect of the immunity continuing? That is what I'm going to address, my lords, only on that aspect. And therefore, kindly have a look at 2 or 3 provisions. First, 6A, my lord, 6A deals only with inquiry and investigation. My inquiry is defined, my lord, my note is there, my lords, may kindly have a look at my note. We'll talk to the other side. There are 4 of my submissions, my lord. The prohibition under 6A is at the stage of inquiry or investigation, not beyond that, as my lord rightly said. My inquiry is defined under 2G of the code, section 2G of the code, my lord, which I have extracted in para 5 of my submissions, my lord. Inquiry means everything other than a trial conducted under this code by a magistrate or a court. In Hardeep Singh versus State of Punjab Constitutional Bench judgment, my lord, your lordships have held that stage of inquiry commences that have extended insofar as the court is concerned.
That's one.
Arrest is,
Yes.
FIR is first, arrest is subsequent.
Your lordships have held that sanction is not part of investigation because
Correct,
of collection of evidence.
But there is a approval 6A part of investigation.
But it affects only investigation or inquiry. It doesn't affect the trial, it doesn't affect sanction under 19. Therefore, trial can proceed. Therefore, inquiry would be essentially an inquiry under 202 of the CRPC, where the court takes cognizance and then requires some evidence to be laid. That is the procedure contemplated by 202 of the CRPC. Investigation after registration of FIR under 154 or after the court directs registration of FIR pursuant to an order under 156 of the CRPC, investigation commences. So that investigation, meaning thereby collection of evidence, is prohibited because of 6A unless you have the approval, whether it is at the inquiry stage or whether it is at the investigation stage. But trial is not prohibited. Now kindly have a look at
What do you mean to say ki the investigation is prohibited, but supposing an investigation has taken place without sanction, can the trial commence on the basis of
on a
that?
different footing. But trial can commence on a private complaint also.
Correct, that is separate.
Private complaint.
Here it is a question of police officer.
No, I'm on the question of police. My lord, so therefore, my lord, I'm on the larger issue of immunity. So 6A doesn't give him immunity from trial. There may be a scenario where trial can be conducted despite the provision in the 6A. That is my submission. Because in a private complaint, Anpule's case, your lordships have held that a private complaint lies. Then the issue would be, can the court proceed with the matter without sanction? Sanction is not part of investigation. Therefore, sanction hurdle.
Where there is a complaint under 200 and the
will not come in the way of a private complaint.
Correct.
That is one. Secondly, my lord, this is in the context of immunity. There is slight overlap, my lord. The second proposition is this, that the restriction in the 6A is only confined to investigation under the Delhi Special Police Act.
Right.
The lordships have held, my lord, I will cite one judgment, my lord, where the issue was investigation was conducted by three judges bench, my lord, by officers other than the CBI, that is officers coming within the purview of Delhi Special Police Act. The contention which was raised that because of application of Section 3, only the CBI has the power, exclusive jurisdiction to investigate. That was repelled by your lordships, and therefore there may be a case where investigation is carried out by an agency which is not covered by DPSC. If that is the case, there is no protection in the 6A. My lords may kindly have a look. Therefore, that immunity, there may be an immunity or there may be a protection, but that is not absolute or that is not universal, but that is a restricted protection. Have judgment given that Sharma. Huh? Very good. That will be good. Other judgment. Yes, that is page 9 of my written submission, AC Sharma versus Delhi Administration, 731 SCC 726.
1973, 1 SCC 726.
73, volume 1 SCC 726. Relevant paragraph is paragraph 13, which I have extracted, Manoj, at page 9 of my submissions. Judgment is in my compilation, volume 2, my lord. But I have extracted the relevant portion at paragraph 13.
That's fine.
The scheme of this act does not either expressly or by necessary implication diverge the regular police authorities of their jurisdiction, powers, and competence to investigate into offences under any other competent law. As a general rule, it would require clear and express language to effectively exclude as a matter of law the power of investigation of all the offences mentioned in this notification from the jurisdiction and competence of the regular police authorities conferred on them by CRPC and other laws and to vest this power exclusively in the DPSC. The DPSC Act seems to be only permissive or empowering, intending merely to enable the DPSC also to investigate into offences specified as contemplated by Section 3 without imparting any other law empowering the regular police authority to investigate offences. This was under the 1947 Act, my lord. My lords may kindly have a look. And as far as 1947 Act is concerned and also 1988 Act, the same thing which is there, my lord. Kindly therefore have a look at the provisions, my lord. Not much of a difference. The Special Police Act will fix it. Give the judgment to the kindly therefore have a look at the my compilation. Now, 182 of my compilation, the judgment starts because the old section is extracted in this one. By way of the old act, probably 17 of the new act, section 17.
Which compilation?
My today's compilation, that is volume 2 of my today's compilation.
Yes, now which one do you want?
Now kindly have a look, my lord. The relevant provisions will be first, section 3 of the Delhi Special Police Establishment Act, which is extracted at page 729, my lord. 729?
729?
I'm sorry, 185. 729 is of the SCC. I'm 185. Yes. Last two lines.
Okay.
Section 3 of the Act on which principal reliance was placed on Mr. Anthony Reid, offences to be investigated by special establishment. The central government may, by notification the official gazette, specify the offences or classes of offences which are to be investigated by special police establishment. Then, Lord, ordinance we are not concerned. Then kindly have a look at para 14, Lord, at page 188, where the old section 5A has been
You're referring from AC Sharma.
AC Sharma. Yes, please, yeah.
Yes.
Turning now to the Prevention of Corruption Act, we find that this act was enacted March 1947, several months after the enactment of the Delhi Special Police Establishment Act, and for more effective prevention of bribery and corruption. By virtue of Section 3 of the Act, an offence under Section 165 IPC was made cognizable for the purpose of CRPC, notwithstanding anything to the contrary. 165 is now deleted, made part of the new Prevention of Corruption Act. Section 4 provides for presumption certificate. Section 5 defines criminal misconduct and also provides for punishment for such offences. It is further provided for punishment of habitual commission of offences under Section 162, 163, and 165 IPC and renders punishable attempts to commit some offence. Section 5 is expressly stated to operate in addition and not in derogation of other laws. Section 5A, which is of importance, may here be set out. Section 5A, investigation into cases under this Act, notwithstanding anything contained in the Code of Criminal Procedure. No police officer below the rank A, in the case of Delhi Special Police Establishment Act, of an Inspector of Police; B, in the presidency towns of Calcutta and Madras, of an Assistant Commissioner of Police; C, in the presidency towns of Bombay, of a Superintendent of Police; and D, elsewhere, of a Deputy Superintendent of Police, shall investigate any offence punishable under 161, 165, 165A of the Indian Penal Code, or under Section 5 of this Act. Section 5 is now Section 13 under the new 88 Act. Without the order of a presidency magistrate or a magistrate of the first class, as the case may be, or make any others thereof without a warrant, provided that if a police officer not below the rank of an inspector of police is authorized by the state government in this behalf by general or special order, he may also investigate any such offence without the order of the presidency magistrate or a magistrate of the first class, as the case may be, or make arrest thereof without a warrant, provided further the offence referred to in clause E of subsection 1 of section 5 shall not be investigated without the order of a police officer not below the rank of superintendent of police. And then if from information received or otherwise a police officer reason to suspect the commission of offence which is empowered to investigate in the subsection 1 and considers that for the purpose of investigation inquiry into such
What is
offence,
what is the purpose of this?
the purpose is, my lord, under the Prevention of Corruption Act, officers other than the Delhi officers falling within the purview of Delhi Special Police Act are entitled to investigate. And the prohibition is only with respect to the officers coming in the purview of DPSC. That is the proposition that I mean. Now kindly have a look at the new act, which is section 17, so it is almost similar.
And the
Section 17
Prevention of Corruption Act.
Prevention. Therefore, my lord, there is no embargo on other police officers to investigate into the offence under the Prevention of Corruption Act.
Not covered by DSP.
Not covered by DPS, the Delhi Special Police Act, and therefore not covered by the embargo contained in section 6A. This, of course, my humble submission should have been considered in Subramanian Swami's case, and they would have found one more reason for discrimination, but it is not considered. Then, my lord, therefore, now my lords may kindly have a look. Even if the embargo was there, the government servant could have been tried, provided it's a private complaint or provided it's an investigation. Not
Other than DSP.
Not under the Delhi Special Police Act. That is one submission that I am making. Therefore, this immunity is not a total immunity. There are contingencies or there are situations where the officer concerned, despite section 6A, not having been followed, can still be prosecuted and a trial can be conducted.
Can you just point out the portion in Anthony's judgment which says the private complaint is?
Yes, my lord. That I had extracted also. That is para 20. Para 6 of something. I have extracted it para 4, page 4, para 8. Just not that. This is page 9, page 9 of 9.
Just
Page 9 of my
read the AC Sharma. That is the portion which refers to here on the.
Yes, just below that. Trial on a private complaint, my lord. Reference may be made to the decision of this Honorable Court in R.S. Naik versus Antule, 84-2 SCC 500, wherein this Honorable Court has held private complaints are maintainable in corruption cases and held as under. But relevant at 11, I have underlined, my lord. I read from the punishment of offenders in the interest of society being one of the objects in penal statutes enacted for large. I'm reading at page 11. Enact for larger good of the society, right to initiate proceedings cannot be whittled down, circumscribed, or fettered by putting it in a straitjacket formula of locus standi unknown to criminals who save and accept specific statutory exception. To hold that such an exception exists, that a private complaint for offences of corruption committed by public servant is not maintainable, the court would require an unambiguous statutory provision, and a tangled web of argument for drawing a far-fetched implication cannot be a substitute for an express statutory provision. In the matter of initiation of proceedings before a special judge in section 8.1 of the legislature conferring power to take cognizance at 3 opportunities to unambiguously state its mind, whether the cognizance can be taken on a private complaint or not. The first one was an opportunity to provide in section 8.1 itself by merely stating special judge may take cognizance of an offence on a police report submitted to it by an investigating officer conducting investigation as contemplated by section 5. But providing for investigation by designated police officers of the superior rank, the legislature did not fetter the power of the special judge to take cognizance in the matter otherwise than on a police report. Second opportunity was when by section 8.3 a status of a deemed public prosecutor was conferred on a private complaint if he chooses to conduct the prosecution. Legislature being aware of the provision like the one contained in section 225 CRPC could have as well provided that in every trial before a special judge, prosecution will be conducted by a special prosecutor, though that itself would not have been decisive of the matter. The third opportunity was when the legislature will prescribe the procedure prescribed for warrant cases to be followed by special judge, did not exclude by a specific provision that only procedures which a special judge can follow one prescribed for trial of warrant cases on a police report. The disinclination of the legislature so to provide points out to the contrary, and no canon of conflict and permit this court to go into such a hidden or implied limitation on power of special judge to take cognizance unfettered by such requirement of its being done on a police report alone. In our opinion, there is no answer to this fairly well-established legal position that For the last 32 years, no case has come to the notice of the court in which cognizance has been taken by a special judge on a private complaint for offences punishable under the 1947 Act. If something did not happen in the past, is to be sole reliable guide so as to deny any such thing happening, for the law would be rendered static and slowly wither away. So private complaint would lie, my lords may can't be overlooked. Then my lords may, that is
Sanction is separate 197 पे sanction लेंगे नहीं लेंगे जो करेंगे.
so. The next therefore, my lords, as far as the immunity is concerned, it's not absolute immunity. Therefore, as far as 20 sub-article 1 is concerned, and this protection which they are seeking to canvass before this honorable court is not an absolute protection. Therefore, there is over and above what the learned SG has argued that it applies only to convictions. This is an additional point that even if it is assumed that it applies to protection, their protection has to be absolute, not a truncated protection as now I have demonstrated. The next submission is this, Madhya. Supposing it is held to be prospective, the Subramaniam Swami's judgment is prospective, and that 6A, on the date it was enacted till Subramaniam Swami's judgment, was in force and applies. Then two situations would arise. One is that evidence is yet to be collected because there is no approval under 6A, or evidence has been collected in breach of 6A without approval. If 6A permission would have been granted, they would not be here before my lord. So it is assumed that 6A approval has not been granted. So two situations arise. No approval, you have collected evidence, either partially or totally, or no, and you have not collected evidence. Let us take scenario number 1, where evidence has been collected, because investigation means collection of evidence. If in breach of a statutory provision, like 6A, evidence has been collected, what would be the effect? Even assuming that 6A is mandatory, would they get any protection? The question which I'll have to answer, according to me, no protection will be granted. Court can still take cognizance, and if cognizance is taken, that cognizance cannot be set aside on the ground that the evidence was collected illegally. This is as far as the first part is concerned. The second part is this. Supposing evidence is not collected, and the police now want to collect evidence. But now if they want to collect, there's no question of giving any approval under 6A because 6A is not in force today. Therefore, the only thing is 17A. So today, they will have to get an approval under 17A. Because today, 17A clicks in. You cannot now say, no, because the evidence you are collecting today, but the offences or the investigation was to commence prior to Subramaniam Swami's judgment, you get an approval under 6A. There can't be an approval under 6A. Because
17A, according to you, applies to pending cases under inquiry or investigation.
17 applies to investigation. Kindly have a look at 17.
No, it refers to both inquiry and
inquiry. It
There's
refers
all
to
the
three things:
distinction between
inquiry, and investigation. Three things.
So
therefore,
it applies to all pending matters where investigation and inquiry is pending.
It applies. So they would get protection of 17A if today we want to commence the investigation.
But after the charge sheet is filed, suppose the charge sheet was filed before 17A, then 17A doesn't kick in.
It doesn't apply because it's not a stage of inquiry, investigation. Inquiry means preliminary inquiry. Inquiry means what I've read 2G. Investigation is 2H. Now, as far as if the charge sheet has been filed and cognizance taken by the court, is answered by Rishwood's case. Kindly have a look. I've extracted in my submission. It's 7. That was a case followed under old section 5(4) of the Prevention of Corruption, where offences could not be investigated by officers below the rank of Deputy Superintendent of Police. The exception was that a low-ranking officer can investigate provided the magistrate passes an order empowering him to investigate. Now what happened is, in this case, inspectors investigated. And the magistrate gave permission in April 1951 or August 1951. The charge sheet was filed after the permission, but most of the investigation was done prior to the permission. In some cases, the investigation was completed prior to the investigation. So there was no investigation by a competent officer. And the Lordship in this first case said that the provision that an investigation cannot be done by a particular officer is mandatory. But even if there is a breach, that evidence can be looked at. Kindly have a look at 3 paragraphs. Page 3, para 7.
Yes.
You are referring to your volume?
My written submission.
Written submission.
You extracted Rishbhat's case there.
Yes, sir. So that it is easier, but no referring.
The
I
both
thought it
proposition
was-
which you are mentioning is mentioned in paragraph 6, page 3.
Yes.
Evidence already gathered as
Yes.
part of investigation.
Evidence not so gathered because of prohibition contained in so and so. In case of situation 1, where evidence is gathered, the question which my lords put to me, my lord. Issue will boil down to whether such evidence is used in the trial in view of the bar contained in 6A of DSP, which was not struck down at that time. In case of HL Dispute versus State of Delhi, 1955 1 SCR 1150, this Honorable Court was dealing with Section 5(4) of the 1947 Act, which did not empower officers below the rank of Deputy Superintendent of Police to investigate any offence under 5(2) PCL, which is 13(2), my lord, of the 88, without the order of magistrate. In the said case, permissions were given by the magistrate in March and April 51. The charge sheets were filed by the police officer other than Deputy Superintendent of Police in August 1951. However, investigation was entirely or mostly complete before the magistrate gave permission. 2 questions which arose before this Honorable Court, which were framed as under. Court, my lord, on arguments as before us, 2 points arise.
Raju, all that you are saying is any illegality associated investigation will not vitiate the trial. That is the.
Yes, I will not issue
This
the
would say,
trial.
right.
And 6A is relating to investigation.
That's the crux of it. That's all that.
Therefore, whether 6A is followed or not followed really doesn't make any difference.
Yes,
As far as trial is concerned,
that's my.
trial will not be vitiated.
But 17A, if it is investigation not carried out, 17A has to be followed. That's my submission. There is no escape from 17A till it is struck down or whatever it is. But since I'm told that the matter is pending for this one.
No, same argument will apply to 17A also.
Okay.
Because investigation is carried out in breach of 17A, but logically extended.
Yes.
What is the purpose of these enactment sections? No relevance.
No, I'll tell my lord the purpose. Your lordships have held that it must be raised at the earliest point of time and you must plead prejudice, plead and prove prejudice. If you plead and prove prejudice, and if it is raised at the earlier point of time, maybe it can have some effect. That's the answer.
At what, in which forum should you raise this plea? Regarding investigation being not carried out under 6A, not at the stage of trial,
You can raise it under 226 before the High Court.
under 226.
You can raise it under 226.
And how does one know whether some investigation is going on or not? Nobody knows.
They would at least know that it is in breach of.
All right, that's your submission.
These are those other submissions that etc. Which the learned SGS argued, I adopt those. This is all that. There are judgments that prejudice has to be pleaded, and if not pleaded, then it can't be allowed. But that there are judgments there in my compilation. If my lords want me, I'll cite those judgments.
In fact, some place in Risbur's case would say that if it is pointed out, court cannot take cognizance unless the defect is cured.
Yes. So at the earliest stage, therefore I said at the earliest stage it has
That
to
defect can actually not be cured once the investigation is carried out without 6A permission, which creates a
But
complete
then there
embargo.
is
Then
another
how can
answer
that
to it, Murad.
defect be cured?
Just see,
You can have-
paragraph 10 of this book, first 3 or
Yes.
4 sentences, paragraph 10, that covers it.
Before I go to risk good, one submission more. Supposing there has been a breach of secret, doesn't preclude further investigation after taking permission.
That's right.
Therefore, it can be that breach.
Prior to that, what will happen in post 6A's permission
That
investigation?
breach can be breached.
That breach can be
Unbreached. Unbreached. Okay, my lords are asking me to read.
Paragraph 10.
Yes, ma'am. It does not have a follow that the invalidity of the investigation is to be completely.
Just one second.
Judgment. But then the whole
Invalidity of the investigation is to be completely ignored by the court during trial. When the breach of such mandatory provision is brought to the knowledge of the court at a sufficiently early stage, the court, while not declining cognizance, will have to take necessary steps to get the illegality cured and defect rectified by ordering such reinvestigation as the circumstances of an individual case may call for. Such a course is not altogether outside the contemplation scheme of the code as appears from section 202, under which a magistrate taking cognizance on a complaint can order an investigation by police, nor can it be said that the adoption of such a course is outside the scope of the inherent powers of the special judge, who for the purpose of procedure at the trial is virtually in a position of magistrate trying a warrant case. When the attention of the court is called to such illegality at a very early stage, it will not be fair to the accused not to obviate the prejudice that may be caused thereby by appropriate orders at the stage, but to leave him to the ultimate remedy of waiting till the conclusion of the trial and of discharging this somewhat difficult burden under section 537, which is now 465 of the Code of Criminal Procedure, making out such an error. No, 482, I'm sorry. Such an error has in fact occasioned a failure of justice. It is relevant in this context to observe that even if the trial has proceeded to the conclusion, accusers had to make out that there was in fact a failure of justice as a result of such an error. Explanation to section 537 of the Code of Criminal Procedure indicates that the fact of the objection having been raised at the early stage of the proceedings is a pertinent factor to ignore the breach in such a situation when brought to the notice of the court would be virtually to make a dead letter of the preemptory provision which has been enacted on the grounds of public policy for the benefit of such an accused. It is true that preemptory provision itself allows an officer of the lower rank to make the investigation if permitted by a magistrate. But this is not an indication by the legislature that the investigation by an officer of the lower rank without such permission cannot be said to cause prejudice. When a magistrate is approached for granting such permission, is expected to satisfy there are good and sufficient reasons for authorizing an officer of a lower rank to conduct the investigation. Granting of such permission is not to be treated by a magistrate a mere matter of routine, but it is an exercise of judicial discretion having regard to the policy underlying it. In our opinion, therefore, when such a breach is brought to the notice of the court at an early stage of the trial, the courts have to consider the nature and extent of the violation and pass appropriate orders for such reinvestigation as the case may be, for wholly or partly, and by such officer as it considers appropriate with reference to the requirements of section 5A of the Act. In the light of the above consideration that the validity or otherwise of the objections as to the violation of 5.4 of the Act has to be decided, the course to be adopted in this. Therefore, I'm sorry, but even the magistrate is empowered. That is what my lords have said, not only the High Court under 226.
But therefore, there's somewhat distinction between sanction and this permission.
Yes.
Sanction may be at a particular stage mandated.
Sanction is usually
In a particular stage,
collected. And,
it may be mandated, depending upon the language of the provision.
yes. But
Because want of sanction has its own consequence.
one more thing that I must submit is this: supposing the lordships hold that the judgment is prospective and not retrospective, the operation of the judgment is prospective and not retrospective, then what would happen, my lord? Would it require the government to give approval under 6A? Post. Supposing they say the police wants to conduct investigation today, and your lordships hold that the judgment is prospective, then Such holding would require the government to give an approval under 6A, which is declared to be invalid.
There may be other practical difficulties also. Suppose during the course of investigation, this judgment had come.
Yes.
Then, in terms, they may not have taken approval. Neither they would have laid evidence with regard to the approval under 6A.
Yes. And that's all right. So this is all that I have to submit, my lord. May I leave, my lord? I am required in the court.
Anybody else to say anything?
But I want to make a brief submission.
You
We
can-
have very substantial issues,
you can do it.
and I want to.
Yes. May I leave, my lord?
I want to make certain submissions.
You have to say anything, Mr. Datta?
Just 4 points I want to say, just very short one. Just 1, 2, 3, 4.
Just wait. Yes.
You would like to mention something about the.
May I just, if my learned friend allows me, but then I'm itching in another form, may I just few minutes that I.
Yes.
The first thing is,
Come.
I think in these matters, what fell from your lordships in the morning is something that we should clearly bear in mind. The issue before your lordship was in many ways a very narrow issue. The question is only about whether the judgment of Subramanian Swamy should be made applicable prospectively or not. And your lordship, I think, in many ways rightly told me that even a 197 issue should not be argued, though there are many complexities of 197 in the context of conflicting judgment, but that's something which doesn't arise. My learned friend just now has opened up issues which have some very, very serious implications. There is entire body of law which has not been placed with your lordships on which should have been placed. And I don't think that it is appropriate that your lordship should expand the scope to go into these questions on inquiry. What is the inquiry?
Desai, please not on that. What he is saying is, when the question
Consequence.
when the question of immunity is there, while deciding the question of immunity, please bear in mind the ratio of these judgments.
I don't dispute.
Therefore, he's not expanded in that sense.
It's expanded the sense because a lot of the concepts on inquiry, which he says really doesn't apply in the context of 6A. Please bear in mind, 6A came into the statute in 2003. 6A was not there when all these other judgments were rendered from the time of Rishwood in the 1950s. The principle of 6A was really a safeguard to the commencement of an inquiry or an investigation. It had nothing more than that. And that safeguard, we may call it a sanction, we may call it a permission, we may call it a consent. But the underlying principle for that was essentially that even to commence an investigation against a public servant causes harassment to the public servant. And therefore, somebody within the government will make an assessment of the allegation and then determine whether this is a fit case to expose that public servant to an inquiry or an investigation. Because otherwise, as the learned SG rightly pointed out, that policy paralysis comes in. We've always seen it. I must say, having also dealt with cases on these matters, over the years, in many matters, there's been a policy paralysis. The concept of public servant is not the concept of a government servant. Please see the definition of public servant is expanded. Panchayats, cooperative societies, all kinds of people of public, those who discharge public duties. The impact of this to limit it has some very serious ramifications because the definition of public servant under the 88 Act has been expanded from the from the IPC, Section 21. So the trend and the legislative intent has been to keep granting some level of protection so that public servants can continue to act fearlessly in the discharge of their duties. Therefore, when a complaint comes from a citizen, whether that complaint is a matter to be investigated or inquired into because it otherwise impacts the public servant in the discharge of his duties, is a matter which the government or the appropriate authority has to take care of. And that is the reason why in 1969 we had the single directive for which was wrong. Then in 2003 we have the 6A and now we have the 17A. So all that it does is at a much lower threshold, not like the sanction where after collection of evidence, the removing authority has to apply its mind to the material and decide whether that public servant should actually face a proceeding in court. The threshold is lower because you're dealing with a question of suspicion. But the question that arises.
Mr. Raju also say that in case there is a violation of statutory provision, the person has the right to move to the trial court or even the high court.
That's correct. example. Bhajanlal considered a case under the Prevention of Corruption Act. What happened in Bhajanlal while saying down the illustrations is that they said that if there is a statutory bar, it's a ground for quashing of the FIR. 5A under the old Prevention of Corruption Act was violated because what was 5A? 5A was to say that an officer of a certain designation or rank will investigate the case. Your lordship said that 5A is violated. I can reinvestigate and recollect the evidence. Why is it that the legislature has said that a public servant investigation should be ordinarily done by a senior officer and not by a junior police officer? That is one level of further protection to a public servant who understands the discharge of the duties and is responsible. Why is it that the legislature says that Prevention of Corruption Act cases should be tried by session judges? That's senior experienced judges. The legislative intent is that all that 6-8 did was to give that added level of protection or safeguard. Your lordship is saying it's a protection. It's a safeguard for public servant in the discharge of all his duties. And since the appropriate authority understands the nature of the allegation which is being made, because citizens may make all kinds
Mr.
of...
Desai, this argument has limited significance. His answer to his submissions of complete immunity. That was the only point which he made.
All I'm saying is that it only really, if your lordship were to, as I said, I don't know how your lordship is trying to do it, but in the morning your lordships have a view. If all that is there is that the question of 6A is upheld because there's a lot of law surrounding all this. What is the legal implication? Evidence collected, is it valid, invalid?
Morning, I said we will not go beyond.
That's all I'm suggesting, because if your lordship sees, I think it is only because one is opening up so many different dimensions of criminal law, which will not be possible to deal with, and the implications of all that, because my learned friend is probably anticipating something else that may happen out of this, this observation. I think there is a body of law starting from Rishwood, which in many ways deals with the implications of all that. Over the years, your lordships have dealt with it. The question is today, should your lordship sitting in 5 judges without having the conspectus of all this once again start dealing with these aspects? And my humble submission to your lordship would be that we should not expand the scope, because otherwise we don't know where we are landing ourselves. As your lordship says, of course, it's very good for the bar because we'll be sitting here and arguing on it. But I must tell your lordship, just as an example, Constitution bench in state of West Bengal versus Ghosh talked about 53 as the only provision under which 20 comes in. Actually, penalty has been, your lordship have now determined the scope of penalty in a series of judgments. So that one has its own ramifications and implications, whether that's right, wrong, in some context.
We'll confine ourselves to what is before us.
And therefore, I only need to point out later on only one judgment which I think will facilitate what is falling from your lordship and what your lordship desires to do, because there is a direct judgment in the context of criminal matters. If I may take a minute of your lordship's time, or we may do it immediately after.
Immediately after.
Immediately. I'm to assist the court and like to urge the court to possibly limit your lordships only to the question that is coming up in consideration.
I told the solicitor also, I'm telling you also. Take it assumed and granted. We will not venture here and there.
I'm deeply grateful because the complexity that I must tell your lordship just one additional point that after the 2018 amendment to the Prevention of Corruption Act, the entire landscape of the Prevention of Corruption Act was significantly changed. Your lordship will see the kind of changes that have been brought about once again, because exactly what the learned solicitor said is that what the government realized a matter of policy was that many of the provisions were causing lots of policy paralysis and matters were not moving forward. Therefore, there was a select committee that was set up to consider the amendment. There was a bill that was proposed in 2013, then ultimately approved in 2018. Your lordship sees the whole approach, legislative approach to dealing with corruption cases also significantly changed. The implications of all that are pretty significant.
We have to deal with
So therefore, I would urge your lordship that I'm only saying that
carry forward. It's a little carry forward which has occurred, which is what we have to deal with.
That's the only limited issue I would urge, because the consequences of many of that, particularly some of the issues that the learned additional solicitor raised, I think have some serious ramifications. Maybe in the facts of an individual case, the consequences can be considered, where the stage of consequences also, as your lordship have held, will determine what is the order to be passed. Because sometimes at the initial stage, sometimes at the stage of framing of charge, sometimes after some evidence is led, sometimes at the stage of conviction. There are all these patterns which are there, and where your lordships have held in different ways how it should be dealt with, and discussion is obviously given to the trial court in order to determine whether this provision was mandatory, which vitiates the entire proceeding or not. So those are matters which will have to be considered in the facts of a given case, rather than to lay down some larger principle without assessing it. So therefore, coming back to the issue that really troubles your lordship today, just one illustration which is somewhat similar in the realm of criminal law, where what your lordship had occasion to deal with in the context of prospective and retrospective. May I just hand over one judgment? Just give her in that. I'm not going to take your lordship through the series of judgments. Your lordship recollect in Mohanlal, your lordship sitting in 3 judges took a view in a narcotics case that a investigating officer cannot be the complainant, or the complainant cannot be an investigating officer. It vitiates the entire proceeding. And in Mohanlal, your lordships took a view that if the complainant and the investigating officer is one and the same, the entire conviction is vitiated. That was the view that was taken. The question that then came up for consideration was, if this is the law, then what happens to all the other convictions? Because ultimately, your lordship is dealing with fair trial. Fair trial is not just for the accused, but it's also for the state and the victim. So in the context of balancing the principles of fair trial, what happens? So the question that troubled the court subsequently, which was a separate bench, not even reviewing the same matter, separate bench, is what happens if this proposition will overturn convictions which have already been confirmed because of this proposition of law. When that issue came before your lordships a few months after Mohanlal, this is the way your lordship dealt with the matter. And that's why the one issue which my learned friend said is it should be the same bench. Your lordship will see here a separate bench recognizing the problem.
Keep doing every day.
That your lordship does. Therefore, this was the context. Your lordship will just mark the paragraph, because your lordship will just contextualize it from paragraph 11. The principles and why your lordship should therefore clarify the matter. If your lordship just give me a minute to just read a couple of sentences, the paramount consideration being to interpret the law so that it operates fairly. The facts of that case did not show any need to visualize what all exceptions must be carved out and provided for. The attention of the court was also not invited to the need for considering the carving out of exception. The individual rights of accused are undoubtedly important, but equally important is the societal interest for bringing the offender to book and the system to send the right message. Then para 13. Law has to cater to a wide variety of situations. Law being dynamic, the certainty of the legislation appears rigid at times when the circumstance.
Mr. Desai,
Handed over the wrong judge.
What you are handed over is
Mohanlal.
Sorry, the second, I'm so sorry. I didn't want to read Mohanlal because Mohanlal is now being considered prospectively, and that's all I want to trouble your lordship with. Please, don't trouble your lordship with Mohanlal. Barinder is the This is where they clarified that it is prospective as a separate bench.
So the only reason you are citing this is to show that the prospectivity is an issue which was decided by a different bench here.
By a different bench, it also, in a sense, sets out the considerations as to when your lordship would need to clarify.
Not a different way, but the case was different. Right?
No, case is different, bench is also different.
Slightly different.
Slightly different.
One judge is changed.
One by three different.
That's right, but you'd say.
Authoring judge will say.
Which are the paragraphs? Just refer to the paragraph.
Paragraph 11,
Yes,
paramount consideration.
that you read.
That I read, then para 13, law has to cater to wide variety, law being dynamic, certainty of the legislation appears rigid at time, whenever a circumstance appears which is not catered for explicitly. Expediency then dictates that the higher judiciary, while interpreting the law, considers such exceptions as are called for without disturbing the pith and substance. Because here is the issue of pith and substance, that the safeguard was not.
But those are not. What is relevant, I think, is only para 15.
And then para, lordship have had already gone ahead.
15 is the only relevant so far as the aspect you are saying.
Not the aspect. That's all. And the consideration. So therefore, all I would say that since this is something, therefore your lordships may therefore look at the narrow issue. If your lordship,
You don't have to, both sides don't have to re-emphasize that. Mr. Datar, what do you have to say?
Very, very brief, just a little. But my first submission is going to be with the references in the context of 23, and I am only requesting my lord that this is a time where we can really look into 20 in bracket 1 once again, which is what Justice Mathur wanted in 2004, and then we were able to persuade the bench. Yes. Now, sorry, you were to say.
Procedure and substantive is a different situation.
No, I am only going to say that 6A should be treated as a
Import, and clearly in view of constitution benches, we can't import a US point of view to the Indian point of view. And then to that extent, solicitor is right, that means you're seeking a reference to a 7 judges bench.
No.
Obviously, what else is it? There are view which has been read, which is quite
I
consistent.
just put my point to say,
Yeah.
the Solicitor General said that the Translation Corporation was in error in referring to US judgments because the earlier judgments in 1950, etc., said that you should not refer to Constitution. Now, what has happened is this. The question of the US Supreme Court judgments which have said don't refer to Constitution is in the context of interpreting the meaning of the word void. That's what Jagannath says, that judgments of the US Supreme Court, Cooley, Willoughby, etc., in the context of void should not be. And these don't American judgments, American authorities, because what was referred to as
The constitution is different, the provision is different.
Yes.
They have a different provision.
no, I tell you what, why?
We can't, this will amount to rewriting.
No, I just think I am not going to belabor on this point. 21 is an ex post facto law. Now, what the Lordship sees that 53 judgment which he referred to that 53 Supreme Court.
Shiv Bahadur Singh.
Shiv Bahadur Singh states.
Rao Shiv Bahadur.
Shiv Bahadur Singh, where their Lordship says that ex post facto law in England, though it is not there in the written, they don't have a written constitution. Yet they have read ex post facto law into a rule of law principle. That's what England is concerned. Then they say for the first time in the written constitution, ex post facto law was introduced in the American constitution. And Justice Mathur then refers to Calder versus Bull, which has been referred to in a number of cases. That's what he says. He says, how has ex post facto law been interpreted in the US? What are the 4 principles? And those 4 principles, he says, include not only the punishment part of it, but also if there are protections in the context of rules of evidence, they are also entitled to the protection of ex post facto law. Now, I don't see any reason why our Article 20 in bracket 1, which is borrowed from the US Constitution admittedly, cannot also take note. It's not binding, it's only personal, it's a point of view, number 1.
To expand like this, knowing our criminal justice system,
Yes.
there are not enough issues already
Yes. No, but not,
which the system faces, then to now, at this stage at least, traverse a path which even further expounds.
yes. No. I'm only saying that the Supreme Court in Translation Corporation should not be faulted for referring to US Supreme Court judgment because Calder versus Bull has been considered again and again by the court, saying that ex post facto law was first explained in Calder versus Bull and subsequently followed in the context of ex post facto law. What are the dimensions of ex post facto law? It's up to your lordship to say, no, I take a different path. I'm not feeling. But our Supreme Court has said, this is what Calder versus Bull said, we are following it. In many cases, as far as we are, even now we are referring to English cases like Anthony, etc.
I have no hesitation in reference, but I would say reference has to be to context.
Yes.
And we must, when we are dealing with the constitution, we must take note of there may be principles expounded there which may be capable of being imported. We are not putting a blanket ban.
Yeah, that's what I.
We are not putting a blanket ban, but it depends on the wording of the constitution there and this to be able to construct.
That's what summarized. No? There is no prohibition. There is no allergy to referring to the US or the UK Constitution, the Canadian Constitution. Because, for example, when the revenue bar, the Madras tax, the national taxation tribunal was struck down, they refer to Canadian judgment, they refer to UK judgment, they refer to. So, wherever your lordship wants to interpret, it can be referred to.
Or if it gives rise to something which needs to be debated,
Yes.
and there is a view taken even by a foreign court, there is nothing which prevents it to be referred to persuade the court to adopt that course of
As
action.
an aid to interpretation. As an aid of interpretation. That's what I'm saying. Now, my lord, I'm going further. Now, my lord, when solicitor referred to judgments or saying that 21 is absolute ghost, etc. I'm only requesting one caveat or one caution here. All these judgments in the 50s are in the context of Gopalan doctrine, which said that you take articles in silos, and if your lordship kindly sees, barring furtherly, Justice Mukherjee and Justice Vivian Bose, most of it was on a conservative basis, saying that treat the articles in a literal way. That was the general trend. And the dissent of furtherly, Vivian Bose have become the law later. I'm only requesting, my lord, in bank nationalization for the first time, they said don't read articles in silos, articles are interdependent. And your lordship also was a member of the Puttaswamy Brigade. Puttaswamy in paragraph 324, 259, just because there's no time, 259 says, we should not focus on the originalistic interpretation of the constitution, but take into account the developments of the law. The lordship has said that don't focus on the originalism. There's also just one point in paragraph 291. Lordship says that all articles are interdependent. And my lord was pleased to hold that Article 14 illuminates Article 21, animates Article 21. I'm only trying to request the Lord, if 14 can animate 21, is it not time to pause and think, can 21 also animate Article 20, Clause 1? This is what I'm trying to put. It's a new point, not to reject it, but it definitely merits consideration.
You are entitled to expound that proposition.
Exactly. Exactly. I can try. So what I'm submitting is, this is a time where what the Supreme Court in Transaction Corporation says, just not immunity. They said the substantive rights of the accused or the immunity. And if you lordship see the judgment referral order in paragraph 6, we took almost an hour to persuade the court not to take a view. First view expressed was, oh, nothing, once the law is declared, it's all gone. It took a lot of effort. That's why they said finally they were able to persuade us what the court records. We went into all the law and said that look, this is a time to reconsider the scope of 20, 21, etc. And then the court records that 23 covers 20 in bracket 1, covers substantive rights and immunities. So that's the point. So I only have a submission is, we see this Matthew's judgment where he emphasizes what is the significance of procedure. I think it's a very outstanding judgment which says that procedure is the bastion of personal liberty. And you can't take 20, 21, 22 or the three articles dealing with liberty in the Constitution. In part 3, Lordship finally says 20, 21, 22 is like a trinity of liberty. So just try and consider that I'm not going to belabor the flag.
We have to also look at, sometimes we forget a victimology principle.
Yes.
There is a victimhood. Here, in matters of corruption, the state and public society becomes the
Exactly. I'm not saying no. I'm not saying no. What I'm saying is,
take it to such a level.
No,
I'm not that we should not punish anybody for anything.
I don't say that at all. What I'm not saying is, if legislature has consciously given a substantive right to a civil servant, saying that he will not be prosecuted without a prior approval, if it's a substantive right given, which is in the nature of an immunity, as your lordship put it, the better word is protection. If that protection is given, and lordship is not a debating society, so we are not going to general laws, in the context of 6A, in the context of 20 clause 1, in the context of 21, can we not say that 6A was a substantive right, was a protection, was an immunity given to the accused, given to the civil servant in larger public interest, and this public interest has been further interest.
Larger public interest is both ways. Larger public interest
Correct.
in giving them availability to take decisions independently,
Really fair.
but also The fearlessness should not be that fearless, which all of us suffer periodically.
I'm not saying no, but I'm not saying. I'm only saying that what is the concept, what does the Supreme Court say? That if you got a protection, if you got an immunity, will it be a facet of Article 20 in bracket 1? I'm saying it should be a facet of 21 if you are watching to reach the spirit of 21 also and see the whole concept of the constitution. Can be balanced, that's the point. And secondly, my learned friend has quoted that one judgment has explained the other. No better example of PMA by 11 judges, but explained by Inamdar, because of some problems created.
Labor on that.
Yes, that's one. Then third, last point I wanted to mention was, a lot of reference was made to prospective overruling. I'm only saying prospective overruling doesn't arise in this case because prospective overruling comes when you overrule the judgment. This is a totally different case where the court struck down 6A. What is the effect of the judgment? And you also said, please don't read Goan Industry and Kailash Sharma and the other line of cases, Madhav Reddy, where your lordship is giving enough guidelines. So your lordship said that we know the point, I didn't want to delay it. I'm saying that let us not get into prospective overruling and Golapnath and Blackstone. That doesn't arise in this case. So these are my humble submissions. And I would humbly submit that the 17A itself manifests, as put it repeatedly, the intention to continue this immunity, to continue this protection. So if it was an amendment, what should I say? It's a clarificatory amendment because the protection existed before, it existed after, it is after. Therefore, in the address, it has to be read to be continued. That would have been the thing as far as interpretation is. And lastly, I just wanted to repeat, one thought came to me, one test by the court would be, if this was done by the legislature, would it follow the ex post articles? That's a hypothetical question you must ask yourself in my humble submission. And our answer will be, if 6A was amended in 2014 retrospectively, I would dare say that your lordship will be pleased to strike it down as being completely arbitrary.
Yes, Mr. Kishore. No, nothing. No, Mr. Kishore has to argue.
No, only one line. Only one line. Nothing. I'm not argument.
Sometimes I wonder how does the US court do it? Half an hour each argument, each side has. And a synopsis. We have multiple synopses, 11 volumes of judgments. Let's bring some discipline into our system.
One judgment cited is overruled. That's what I'm saying.
It can't go on a
I
debating
will
point.
take only 10 minutes.
Yes, Mr. Kishore.
Mr. Mehta. Milord, page 33 of my compilation. That will settle many issues.
Oh.
This question of prospectivity, retrospectivity or retroactivity rather will go. Page 33 of my main compilation. Para 8. Now, my lord, I have headed it like facts and chronology of the respondent's case do not allow retrospective operations. Can I read, my lord? No, sorry.
Yes.
The fundamental question is,
Just one.
Yeah, page number.
page number 33 of my compilation, para 8.
Facts and chronology of respondent case.
Can I go read it now?
Yes, yes, go ahead.
Now, the fundamental question is as to which law should be applicable in a case. Obviously, the law existing at the relevant point of time should be applicable. Now, the question is, what is the relevant point of time?
These you had read the dates to show to us the stages at which it had arisen. Mr. Kishore.
It is 33, page number 33.
I said in your opening arguments, you had referred to the stages as the stages of when case is registered.
Yeah, yes, my lord.
These dates you had read. So you were said there were different stages at which happened.
Yes, there were different stages.
Yes.
Stage 1 was, because my question, the question which I am putting to myself is that if a case keeps on pending for 10 years or 20 years or 30 years, and during that period the law keeps on changing, which law shall be applicable to that particular appeal? Okay, that question I framed, that I am trying to address with the factual matrix of this case. So this case has certain stages. What was the stage 1? When the case was registered against the respondent, that was stage 1. The stage 2 was when the High Court Honorable High Court delivered the judgment declaring the CBI action as illegal. Section Stage 3 was when the CBI filed the appeal in that judgment in this honorable court. Stage 4 was when the pleadings were complete, when the counter affidavit, etc., were filed and exchanged. And stage 5 was when the matter was being heard finally by this honorable court. Now, during all these stages, the law applicable was Section 6A. Right from the time of initiation of investigation till the time the matter was ripe for final decision, until the time the Union of India had occasion to file a detailed affidavit agreeing with the judgment of the Honorable High Court. That was in 2012, when Section 6A was in existence. Now, during pendency of the case, Section 6A was wiped out. Let us say wiped out, although it was declared as invalid. But let us say it became void. Now the question is that when a case is pending before this honorable court or any other court, and as in this country, they keep on pending for decades, not for years or months. For example, this case has been pending for last 14 years in this honorable court. Now, during that 14 years or 20 years, law will keep on changing because law is a work in progress, keeps on changing, depending on the socio-economic imperatives and a host of other values and other imperatives. Which law will be applicable to the case? That is a fundamental question. So my humble perception is that the law, either which was there at the time of commencement of lists, or which was at the time of challenging that action in the Honorable High Court and the time of deciding by the High Court that, or when they challenged that judgment in the Supreme Court that, or when the pleadings were complete and the matter was ripe and due for final hearing, that must be applicable. And pendency should not be made as a ground to the change of applicability of the law. And why I say so, now para 10 of my, para 10 on page 36. I have edited law cannot be subordinated to fortuity. Now, the question of applicability of Section 6A judgment is arising only because the appeal filed by the CBI has been pending for a long time. After passing of the impugned judgment of the Honorable High Court, that was on 5/10/2006, introspective application of the Subramaniam Swami's 6 May judgment, 6 May 2014 judgment, in the respondent's case means that it is the pendency of the case which will determine as to which law should be applicable to a particular case. When a particular case will be finally decided is a fortuitous circumstance. Some cases are decided early, some cases get delayed. Had the appeal been decided earlier, when it was ripe and due for decision, that is in 2007, the question of applicability of Subramaniam Swami's judgment would not have arisen. Applying 6 May 2000 judgment to a respondent case means that judicial decisions are being subject to 40.
The law will apply. You can't say because my matter is pending, even if the law is changed, chain law will not apply. Of course, what principle of law will apply is different. How can you? Judgment just changed. There is a question. Yes. Anything else?
Now that is one point.
Yes.
Another profound point which the learned AIG has raised, that if there is a statutory requirement in the law contemplating some kind of section or approval, prior approval or permission, and if it is not taken, then the proceedings are valid and the accused has to prove that some real prejudice has been caused to him. If actually the prejudice has been caused, then only that act of not taking sanction or approval shall be taken into consideration. So on that, I have quoted about in my compilation 7 pronouncements right from the time of Privy Council. The first judgment is 1948 in Dwarka Das Moratna versus the king, where they said that in the criminal law, when a mandatory procedure is prescribed in the law, the investigating agency or prosecuting agency do not have a discretion or choice. They have to comply with it meticulously. And if they don't, then it amounts to prejudice per se. And they have not only quashed the proceeding, even the convictions have been quashed. I have got 6 judgments from this honorable court, including one from the Privy Council. And when all these things happen, that otherwise what will happen? An investigating agency or prosecuting agency has been mandated by law to follow a certain procedure. They may follow it, they may not follow it. And then the burden is cast on the accused that to prove that the prejudice has been caused. So the law will be reduced to a nullity because they will not follow it. And this question came in the Vineet Narayan's case, and I'll read what the Vineet Narayan has said. Now this is 1988 SCC 889.
See, you said 10 minutes, we have got 2 minutes, you may conclude. If you start reading, it will not finish. We have spent 6 hours on this matter.
This is last.
Small time.
This is my last sentence.
Okay.
Just kindly read what the Vineet Narayan has said.
Yes, read.
On page 918 of the judgment.
Read out, read out.
Para 29, my lord.
Yes.
The duty, I'm reading on page 909, para 29.
Yeah.
The duty of the court is that such proceeding is therefore to ensure that the CBI and other government agencies do their duty and do so strictly in conformity with laws. In these proceedings, the court is not required to go into the merits of the accusation or even to express any opinion thereon, which is a matter for the consideration of the competent court, in which it is therefore necessary that not even an observation is made. That is the need.
Thank you.
There has to be meticulous compliance with law.
Concluded then.
Any violation constitutes prejudice.
We are grateful to your lordship.
Thank you. Grateful.